Good morning, everybody. I'm Michelle from AmeriEstate Legal Plan. Hope you're having a great morning so far. I sure am. It's beautiful in California. Even though we had some fires last night, about 20 homes burned down, but it's very dry and windy here right now. But other than that, today we're going to talk about divorce or remarried workshop and what you need to know if you are going through a divorce or in what I call the 4 stages of divorce. The first thing I want to say is we're not going to be taking questions during this webinar, but please feel free to pop your questions in the link, or I think there's a chat box there, and we will get back to you because we want you to be fully informed about this subject, because we get an awful lot of calls, existing clients calling us wondering what to do now that they're getting a divorce. So I just wanted to make sure that you know that we can cover this subject, and we're going to do it in about 30 minutes. So today I'm going to share with you the 4 stages of divorce. Yes, there are 4 stages of divorce. Stage 1 is considering a divorce. Stage 2, you're in the middle of the divorce. Stage 3, your divorce is final. And stage 4, getting remarried, because that happens a lot. So stage 1, if you are considering a divorce, here are a few things to think about before your petition is filed. Take all the money and run. No, just kidding. Don't do that because you will get caught, seriously. But if you already have a plan in place with your spouse, start thinking about at least updating your powers of attorney right now, because those documents are your private documents. And when I say powers of attorney, I'm talking about healthcare power of attorney and your financial asset power of attorney. So you can also take it a step further if you want, but the basic thing you should be doing if you're considering a divorce and you're pretty much sure that it's going to go through is you might want to consider at least updating those 2 documents, because if you become incapacitated, end up in the hospital, and you might be fighting with your spouse, they might not be the people that you want to make healthcare decisions for you, right? So just consider that, and I'm going to go into that a little bit more in the next stage. Okay, stage 2, you're in the throes of it. You're in the middle of that divorce. You're fighting it out. You're with the attorneys. You're basically, looks like this thing is going to happen. So again, if you're in the middle of a divorce, get those powers of attorney updated. A lot of people call in and say, can I go ahead and do a living trust for myself, even though I am not divorced right now? And the answer to that is yes. A lot of people want to complete the whole document again, just with themselves, because they will be ready when the divorce is final to receive whatever assets are coming to them after the divorce. And so the key thing to remember here is if you are married and you have an estate plan, if you have an estate plan already with your spouse, you can set up another living trust, put your trust in place, do a new pour over will, get your new powers of attorney done, name guardians for your kids if something happens to your spouse. But you're going to hold that trust and you're not going to put anything in it until the final decision is made and the petition is filed and the divorce is final. Okay, so we can have that document ready for you to receive assets once that divorce is final and the judge declares who's getting what. Okay, the third stage is your divorce is finalized. And here again, some people don't have a trust when they get divorced, and some people have a married trust. We find a lot of our clients call in and they're getting divorced and they already have a trust. And the questions are, what do I do with my existing trust? I'm divorced now. And what do we do with this married trust that we put together? Well, the smart thing to do is you're going to want to revoke that existing trust, because basically whatever the judge says and whatever is finalized, that trumps a trust. So if you have a trust together as a married couple and you have all the plans, who gets what and all that, and when you get divorced, the judge has decided maybe one spouse gets this property, this spouse gets this property. So if you haven't set up a new trust and something happens to you, the old trust is not going to govern. It will be the divorce decree, and in the divorce decree, it will say who gets what property. But the problem with that is if you don't have those assets into your new trust, those assets will now go through probate. So it's really important to plan ahead when you're going through these stages of divorce, to think through it. You know, maybe I should go ahead and just get my trust, my new trust set up. So when that divorce happens, whether it be in 3 months or a year or whatever, you're ready to go and you have your trust. But the key is, do not put anything into your trust, and don't even touch your life insurance policies, your 401ks, your IRAs, annuities, things like that. It has to remain neutral the way they're titled right now until that divorce is final. When the divorce is final, you can start loading up your trust. We call it funding your trust. It's like your suitcase. You're setting your suitcase up to receive those assets once the judge approves and the divorce is finalized. And the third stage is getting remarried. It happens all the time, right? Let's face it, we're all in life together, in life, and we want companionship and a partner, and we find a new spouse that we want to create a new life with. So that can get a little complicated. So I wanted to let you know that you can have more than one trust. Oftentimes people who are, divorced, they've received assets from that divorce and they've put those into their single trust. And now they're married and they're going to keep that asset that they received from the divorce as their sole and separate asset. But when they're married, they're going to start accumulating assets together. So you can have a single trust and keep those separate assets separate with a totally separate plan who's going to receive those assets. And you can have a married trust, like maybe you're going to start combining some assets, buy homes together, properties together. That married trust can receive those married assets. And your spouse can also have his or her single trust as well. So just know that is possible. So the only thing you can't have duplicate are your powers of attorney for health and finance and your will. So we know how to create that and put everything together. So you have one will, one power of attorney for health and finance, and you can have 2 trusts. You can even have more than 2 trusts to hold separate assets. So just know that we can help you craft that. And then another thing to remember is when it comes to married second marriages, we often have the Brady Bunch syndrome, right? We have yours, mine, and ours, and you want to be fair with all your kids. And so you want to be pretty clear on your married assets, how you want your marital assets to go. Maybe your spouse has 5 kids and maybe you have 2 kids coming into the marriage. So we have to think through that a little bit and help you craft your plan that makes sense for you. So sometimes I see a spouse having 5 children and the other one having 2, and they might split the married assets 50-50, with 50% going to the one spouse's 5 kids and the other 50% going to the 2 spouses' kids. So it's equal in the sense of, 2 different families, but not equal in percentages depending on how many kids you had. So just know that when it comes time to setting up your second trust, that you want to be sure that when the time comes to fund, that you also remember to take care of those beneficiary type designated assets. I'm talking about 401ks, life insurance, IRAs, 403bs, things like that you must have a beneficiary on. I have seen this so many times when somebody has divorced and they forget to change or update their beneficiary designations on these types of assets, and they pass away. And guess what? The ex-spouse is left on there, and the ex-spouse gets that money. And it wasn't intentional. They just forgot about it. So this is probably one of the most important things that you need to remember when the divorce is final and the judge approves who gets what. Update those beneficiary designations. And also, if you have minor children, in your new trust, you want to designate who you choose to be the beneficiaries of those minor children. Now, what happens is your ex-spouse usually, no matter what, will get custody of the children if you pass away. That's just the way it is. But sometimes that ex-spouse is not a good person. And I've had a client write in their trust that to spend whatever you need to for the trust to protect my child from being, getting from her ex getting custody of her. So you want to make sure that you put a backup designation on who those guardians will be for those minor children. So I just wanted to make sure that you understand that, divorces, as we all know, can get very ugly. And when you're in the middle of it, I highly recommend that you at least set up powers of attorney for yourself, because anything can happen to you in a divorce with your health or your finances. And if your ex, the person who you are fighting with, is in charge of making your end of life decisions for you, because that's the only document in place, that's a little scary, right? So just be sure to at least get those two documents done. And if you want to take it a step further, get your whole new trust set up and ready to go. And we're going to coach you and make sure that you understand there is no funding allowed right now. Get your final divorce decree, and then we'll help you, retitle properties into your trust, help you understand how to update your beneficiaries, and help you understand what you take down to the bank to update your bank accounts and put those in the name of your trust. Super, super important last step. And I wanted to let you know a little bit about what is in our trust portfolio for those of you who are not our client already, or for those of you who are thinking about getting a trust. Our trusts are set up with the most vital documents that you need. These are the most important documents that you need for your life, really, okay? It's your revocable living trust, which houses who gets what, your beneficiaries, who your trustee is going to be, how the money is going to be distributed, all the instructions, like 25 pages of instructions that, it's all the language to make that happen. And it also helps with any special or minor needs children. Special needs or minor children. There's special language in there that protects our special needs children from receiving assets and possibly canceling their public benefits assets. So you're also going to get what's called your nomination of guardian, your powers of attorney for healthcare, your powers of attorney for finance, your and complete notary service that we will send a notary to your home to get all your documents done. So it doesn't matter where you live in the states that we are in, we can help you. So you don't have to be next door to where we are here in Costa Mesa. Whatever state AmeriEstate is in, we can get your trust done for you and bring it to you to sign and notarize. Another great thing I wanted to share with you is how AmeriEstate works and why we are here today, 25 years later. We formed our company, it's called AmeriEstate Legal Plan. And the reason we did that is we wanted to bring estate planning to Middle America at fixed, affordable pricing. And that is the way we're structured. So every single client that works with us to set up their estate plan talks to the attorney, and that is done over the phone. We have negotiated excellent rates for our estate planning attorneys to talk to you, because we're bringing you to them. They don't have to go out and find you themselves through their own marketing. We're doing that part. So we're able to negotiate better rates with them. And also, because of the way we're structured, we can bring you other advantages and services that most attorneys would charge you about $3.50 an hour to do. So with the legal plan, when you join the legal plan, which is included in your estate planning service that we're doing, you're going to get access to a nationwide network of attorneys if any other matter comes up in your life. So it doesn't matter where it is and what state it is, we can help you get in touch with an attorney who's specializes in that area of law. We're going to do free, simple changes and amendments to your trust. So you just call us and say, I need to change my beneficiary or my successor trustee. Guess what? It's not going to cost you $300 to $600 to do that or more. We're going to do an annual review with you every year on your trust to see what you have maybe bought or sold, or if you had a new child, or maybe somebody passed away and you need to change your successor trustee or beneficiaries. We're also going to give you a 25% discount on any other legal service you need when we refer you to an attorney. So most attorneys charge right now, on the low end is about $350, maybe $250, but I don't see that anymore. They're usually charging about $600 an hour now. So if you need an attorney for any other matter, you're going to get 25% discount off their hourly rate. So it's really good to stay in that legal plan. And also we provide what's called a DocuBank Advanced Healthcare Directive, a DocuBank wallet card, which houses your healthcare directive electronically. So if you're out and about, you're traveling on a ship, you're in Europe, you're just somewhere else where your documents are not, you're going to have this card on you that will activate if you come in an accident or just end up in the hospital. You will always carry your healthcare directives with you wherever you go through the service that is included every year. And we also have a DocuBank safe so you can store all your estate planning documents for free in the cloud, right? We have over 30 employees that work here at AmeriEstate. So when you call in, you're going to get help. Okay, you're not going to go to some voicemail where the attorney's too busy to talk to you. We're going to be able to receive your call and talk to you. A lot of times it's very simple questions and you don't need an attorney to talk to you about those questions. But if you do, we're going to make sure that you get in touch with the attorney and we'll set that appointment. We also have Spanish speaking. So if you're a Spanish speaker and you'd like to deal with talk in Spanish, we can set you up with our Spanish speaking attorney in California. So I just wanted to mention that divorce isn't the only time you should review your estate plan. A good rule to follow is reviewing your plan every 3 to 5 years, but we offer a yearly review at no charge, as long as you're in that legal plan. And the legal plan, by the way, is $150 a year. It's not mandatory, but it's something that our clients really like because they know they can pick up the phone and call just for the simplest of questions. So just know that it's really a valuable thing, but if you don't want to renew it, that's okay too. But we would hope that you would, of course, because we want to be here for you and be able to answer your questions quickly when you call. So I hope that I have helped you understand a little bit about what happens during divorce and the things that you can do in the middle of a divorce and things that you shouldn't do in the middle of the divorce, like putting assets into your own trust. We can't do anything like that, but you can surely set up your own trust before, during, or after your divorce is final. So just know that we're here for you. We want you to feel comfortable about talking about these things with us. We're very passionate and considerate of your time, and we just want you to know that you have a place to call home when it comes to all the things estate planning. So with that said, I'm going to say goodbye and continue on with my day. And hopefully, if there's any questions you have, please put those in the chat and we will follow up with you. And thank you so much for your time. Bye-bye.
Perfect.